Good afternoon. I'd like to call the Finance, Ways and Means Committee to order for October 28th, 2021. Madam Clerk, would you please call the roll?
Representatives Baum, Campbell, Camper, Chisholm, Cochran, Crawford, Faison, Gant,
Here.
Helton, Howell, Lamar, Lambert, Miller, Moody, Russell, Shaw, Vidal, Williams, Wendell, Zachary, Vice Chairman Hicks of Hawkins, Chairman Hazelwood.
Here.
Chairman, you have a quorum.
Thank you, Madam Clerk. Are there any personal orders or announcements before we get started? Any personal orders? Chairman Moody, you're recognized.
Thank you, Chairman. I have some wonderful dear friends in the audience that have stuck with us for a couple of days. Kathy, Chris, and Charlotte, will you wave? And I can't let an opportunity go by to introduce and remind you that Scott Golden is here, our Tennessee Republican Party Chairman. Welcome.
Thank you to our visitors for being here. Thanks to all those who are watching, live streaming us, or will be watching on the video. I would remind you that the documents are available on your dashboard if you haven't had a chance to get a hard copy of them, but they are on your dashboard. We will now be dealing with item 1, which will be rolling to the Hill. Item 2 on our calendar is House Bill 7. I'm sorry. Is there any objection to rolling item 1 to the Hill? Seeing none, item 1 is rolled to the Hill. Item number 2 on our calendar is House Bill 76 by Chairman Vaughn. We will, without objection, roll him 2 spaces. We are now item number 3. Representative Campbell, you were omniscient in knowing that you were going to be at the podium even before we did. Representative Campbell, you are recognized.
Thank you, Madam Chair. It felt
With
right.
a motion
for some
and a
reason.
second.
Yeah, very good. House Bill 9071 is relative to district attorney generals in Tennessee. So let me give you a brief description here, and I'm going to read some of this directly from the language. If a district attorney general peremptorily and categorically refuses to prosecute all instances of a criminal offense without regard to facts or circumstances, then under this bill, the Attorney General and reporter would be able to petition the court for appointment of a District Attorney General pro tem. Currently in our Constitution, and in our law, when you look at those facts, the court is able to make this decision, and this would only be adding that the Attorney General would be able to petition the court for the appointment of a District Attorney General pro tem. And again, the court currently has the purview to be able to decide that and would retain that ability as well. Thank you, Madam Chairman.
Members, you've heard the explanation. Are there any questions? Representative Lamar, you're recognized.
Thank you, Chair Lady. Thank you, sponsor, for your explanation. My question is, if can multiple pro tems be appointed in a county to supplement the decisions?
Representative Campbell.
Thank you, Madam Chair. There is the possibility that if a district attorney general has said, say there are 2 issues that they've decided, and maybe they've gotten on camera and told the media that in all situations, let's say it's murder and robbery, let's be extreme. If a district attorney general stands up and says, hey, I will never prosecute anyone for murder or robbery, that's a situation under which this would apply or could apply. Now, could there be a situation where a district attorney picks more than one subject area, becomes a media darling, and goes out and talks about their views rather than enforcing the laws of this state? Yes, we could run in, I believe, to a situation. I don't think this would be common. I don't think it would be frequent, but I do think it is possible. Thank you, Madam Chair.
Representative Lamar.
Thank you. So it is true that, I say, calling a special session should be rare, but we've done it since every year since I've been elected. So it can be used and overused. So since we're sitting on finance, and I know we indulge in this in judiciary quite a bit, if one pro tem or multiple pro tems are assigned, who has to pay for it, the state or the county district attorney's office?
Representative Campbell.
Thank you, Madam Chair. According to the Fiscal Review Committee, the fiscal note states that the proposed legislation may result in an increase in state expenditures, and they do not mention any local expenditure. In fact, a district attorney is a state entity, and it would be a state expenditure. Thank you.
Representative Lamar.
Thank you, Chair Lady, and thank you, sponsor. So from my understanding, this bill would allow us to, or the courts to honor the petition of the AG to assign to an umpteenth number of pro tems when we have 95 counties out the state. So we can essentially sign as many district attorney pro tems as possible in all 95 counties, and then the state has to pay for it. So we're pushing a bill not knowing how much money it's going to cost the state of Tennessee. So that's my reservations is, we should be able to determine how much money we're got to spend on a position that the people already elected a district attorney in that role. So we're creating multiple positions essentially to circumvent the prosecutorial discretion of the highest law enforcement agent in that county. So I think that we should, strongly think about that as we move forward to pay money to enforce things that the DA feel is best or not best for the county. So I want us to think about that clearly. And if you want to know some of the criminal implications, I highly suggest that you all go back and look at the hearing from judiciary earlier. Thank you, Chair Lady.
Chairman Baum.
Thank you, Madam Chair. This bill would allow the Tennessee Attorney General to appoint a temporary district attorney. Okay, I've got it wrong.
Representative Campbell.
If I may, I'll repeat some of the explanation. All this would do is allow the Attorney General of our state to petition the court for appointment of a district attorney general pro tem. The entire decision will still lie with the court as it does today. This would only create an avenue for the Attorney General, for example, to speak up on behalf of the state of Tennessee in hoping to see that our law gets enforced rather than have a rogue DA who does not want to enforce state law.
Right. Thank you. And I meant to say that. I think I just stated it wrong. Is there any provision that would allow the district attorney general to petition the court to appoint a temporary district attorney general in their place? Maybe they don't want to prosecute the case, but they're somehow sympathetic and they would be willing to petition the court to appoint someone in their place?
Representative Campbell.
So I can't personally speak to that type of situation. I can say generally, though, under the bill as written, the decision is by the court, and this would only allow the Attorney General to ask, or I should say, to petition the court for the appointment of a district attorney general pro tem. And I want to be very clear. This talks about that district attorney refusing to prosecute all instances of a criminal offense without regard to facts or circumstances. So I feel like that's very specific. Thank you.
And Leader Lamberth, if you would care to expound on that for us.
Thank you, Madam Chairman. And to the question, that is already included within statute that a district attorney can step aside if they have a conflict of any kind. It can be a conflict of conscience. It could be a conflict because they know the defendant. It could be anything where they say, look, there needs to be someone else come into this circumstance that's objective that can handle that role. And so that actually happens throughout the entire state. And that's the process that this builds upon, where a pro tem is appointed to handle those responsibilities if for some reason there's a conflict. Obviously, this bill also seeks to address where there's, you may have an elected district attorney out there that chooses not to fulfill their responsibilities under the Constitution. And the constitutional provision actually provides for that as well, that the court can appoint someone if the district attorney fails to fulfill their duty.
Representative Shaw, you were next on my list.
Thank you, Madam Chair. And Madam Chair, if I'm out of order, you call me out of order, but I just want to ask the sponsor if he would tell us where this come from and what county are you basically representing with this bill?
Representative Campbell.
Thank you, Madam Chair. This bill was filed by Speaker Cameron Sexton. I was asked to carry this bill with statewide application. No one has specifically looked at me and mentioned or suggested any specific county. In fact, up my way, our district attorney serves multiple counties. Thank you, Madam Chair.
Chairman Howell.
Thank you, Madam Speaker. Just for clarity, does this bill take away all discretionary ability of a district attorney, or does this bill only apply to cases of emergency such as in COVID?
Representative Campbell.
Thank you, Madam Chair. This is only specifically when a district attorney general refuses to prosecute all instances of a criminal offense without regards to the fact or circumstances. So I think I view that as being very specific rather than, I don't think this will be frequent. And I don't think that this would happen a whole lot. At least I hope not. I think that their oath of office ought to tell them what they need to do and work within the confines of present law rather than going their own way on multiple occasions. Thank you. Thank you, Madam Chair.
Representative Russell.
Thank you, Madam Chairman. And sponsor, I just want to thank you for bringing this legislation. We currently are already doing this for the most part. It only extends the current practice in which you described very well up there. And I'm certain that it'll make the judicial system more fair from a wide range of issues that may occur in the future. Thank you.
Thank you.
Are there other questions of the sponsor? Representative Miller, you recognize.
Thank you, Madam Chair. Representative Campbell, the question was asked exactly where did the bill originate? Are there many examples currently of district attorneys not prosecuting under current law? Are there many examples of that currently?
Representative Campbell.
Thank you, Madam Chair. I did hear some examples today in Judiciary Committee. Representative Beck provided an example or two in this area, and some other members mentioned some circumstances along the way. But this simply, really, frankly, in current law, we already allow our courts to make the appointment of a district attorney general pro tem. Okay. All we're really doing here is opening up the door for the attorney general of our state to be able to petition that court for something the court can already do if they deem it necessary. Yes, sir.
Representative Miller.
One other question, Madam Chair. What happens if a general pro tem is appointed and this general pro tem agrees with the district attorney? Is it, I mean, that's possible, right? What happens at that point?
Representative Campbell.
Representative, that's a situation I've never envisioned, quite frankly. I don't know where we would go at that point, if it would fall solely on their shoulders and be a dead issue, or if this would allow them to then appoint someone else. But unique perspective, with all due respect, sir.
Thank you.
Thank you. It's not an impossible situation, I'll say that. I would imagine could happen.
Representative Chisholm.
Thank you, Chair Lady. To the sponsor, is it common for district attorneys not to prosecute on serious crimes? Is that a common thing?
I would venture to say that it is not common, but it certainly happened in multiple jurisdictions across the state and ends up getting a fair amount of media attention. But the situation here is extremely specific, and that's when they have refused, not in a situation, but broadly, when they've refused to prosecute all instances of a criminal offense. And I want us to remember that is without regard to facts or circumstances. So if you get out here and start doing media interviews with every TV and radio station around, and you pick your topic and whatever it is, I'm no longer prosecuting. In fact, I will never prosecute that. I will never see that law gets enforced that was created by this General Assembly or a past General Assembly. I think that those district attorneys have a very significant responsibility, and I don't want them to fail to carry out their duties, because I like equal application of the law. Thank you. Thank you, Madam Chair.
Representative Chisholm.
So would you say that this bill is kind of making the assumption that district attorneys are not enforcing the law?
Representative Campbell.
I think it's safe to say that clearly some district attorneys in certain circumstances are choosing, yes, to not prosecute a specific category of offense. And we could run into a lot of different situations. Certainly don't know in terms of the future how frequent that'll be in various jurisdictions. But I do think we're seeing more activist types rather than those doing their job and accepting the oath that they have sworn to uphold. Thank you.
Representative Chisholm.
Final question. Have you met with district attorneys concerning this piece of legislation?
Representative Campbell.
I have been in consultation with the representation of the District Attorney General's Conference of our state.
Thank you.
And they've been speaking on behalf of their membership. Yes, thank you.
Representative Miller.
Thank you, Madam Chair Lady. A couple other questions. Earlier, I was in my office and I was listening to the committee. And as you were explaining the bill, you went from criminal activities in reference to marijuana all the way to murder. And the use of marijuana currently is a criminal act in this state. Would you agree with that?
Representative Campbell.
I would agree that under federal law and state law, yes, that would be a crime.
So my question is, under what circumstances would the Attorney General, under this law, decides to make that appointment? I mean, who will initially bring the complaint forward?
Representative Campbell.
Thank you, Madam Chair. This legislation does not attempt to establish a process of who can approach the Attorney General and request that the Attorney General petition the court. I think that would be very much on a case-by-case basis, whether it be members of the General Assembly or the public, if they feel as if, I think we run the possibility there, but there's no definition in this language about who could approach the Attorney General. This just would simply allow the Attorney General to petition the court for the appointment of a District Attorney General pro tem, which I will remind the membership that the court currently has the right to do that. This just adds a permission slip, if you will, for the Attorney General.
Representative Miller.
So anyone could actually approach the Attorney General and say that there's a case in anybody's county, and we think this DA has pretty much violated the law. And then the DA would look into that, he or she would investigate that and make a determination if in fact they want to approach the courts and end up with a pro tem. Thank you.
Representative Campbell.
Thank you, Madam Chair. I believe this would be a very rare situation. At least I hope so. I like to think that those that are sworn to uphold their oath of office would do so and enforce the laws of the state. I feel like they have a major responsibility to the millions of Tennesseans spread across 95 counties. And I just really don't think this will be widely used, but I think that the avenue should be there when and if the need arises. Thank you, Madam Chair.
Thank you. Representative Lamar.
Thank you, Chair Lady. One more question. Will this bill technically specify how long this pro tem will be appointed and serve? And what I mean by that is if the courts decide to honor the petition of the AG, will they serve a year? Will they serve 2 years, 5 years, a lifetime? The duration of the term of the DA? So in regards to us thinking about how much this will cost, if we are paying for new pro tems, how long will we be paying for them to serve?
Representative Campbell.
Thank you, Madam Chair. This specifically would only apply to the circumstances that I've been very specific about, and I'm going to hit that one more time. And that is if the District Attorney General has refused to prosecute all instances of a criminal offense without regard to facts or circumstances. So once we get through that component and the appointment has been made, that pro tem Attorney General would be in place for the sole purpose of prosecuting persons accused of committing that offense. There is not a time limit within the language of the legislation, but it would be offense specific. Try to say that a few times. Thank you.
You're a radio announcer, is that right?
21 years behind a microphone, and that was a toughie.
Representative Marr.
Thank you, Chair Lady. So basically, from my interpretation of your answer is that once a Speaker Pro Tem is elected, they can serve until however you feel like they need to serve. So for example, we have a DA who refuses to prosecute under an ounce of possession of marijuana, knowing that marijuana is either medical or legal, recreationally legal in over half the states in the country. And that DA continues to get reelected and reelected and reelected and reelected from the people in that county, and that continue to keep the same stance on hypothetically small possession of marijuana. The state is going to continue to pay election after election every 4 years, or 8 years, excuse me, because our DA is 8 years. My apologies, 8 years, a separate pro tem just for that issue. Then what if it's another issue they won't change their stance on, and the people of that county keep electing them with that open public media stance? So with the state, we're going to still pay people and pay people and pay people and pay people every time we want to petition a new pro tem on every issue that we don't like, that the DA, the highest law enforcement officer in that county, decides to make that decision. So can I explain to me more specifically, because we kind of danced around it, how long they're going to serve and what cost that's going to cost the state?
Representative Campbell.
Thank you, Madam Chair. So I'll address the cost piece once again, and we're going to look at the fiscal note together for that purpose. The fiscal note states that the proposed legislation may result in an increase in state expenditures. The timing, duration, and amount of any increase is unknown and cannot be estimated with reasonable certainty, and that is after the fiscal review folks have done their work. In terms of the amount of time, I want to be very specific here and tell you that I do think this would be rarely used. I want you to be mindful that the court can currently make the decision to create a district attorney general pro tem if they choose to do that. The court would still be the one making the decision. The court would still be determining who serves as the district attorney general pro tem. All we're asking to do is to allow the attorney general to petition the court for something that the court can already do. That's all we're doing, is asking permission for the attorney general to be able to petition the court. Now, we could go get in the weeds on a lot of these different issues and hypotheticals, and I'll go back to you, Madam Chair.
Representative Lamar.
Thank you. I would just want to follow up and let the committee know on the financial aspect. In this bill, all of us, Democrats and Republicans, have the ability to ask the AG, all of us, for every single bill we may potentially pass, to petition the courts to assign a new pro tem. There's an unlimited number of pro tems that can be assigned with the unlimited number of 95 counties, with the unlimited number of pro tems, with the unspecified time frame. So we're committing to expenditure that we have no idea of what it's going to cost. And I would disagree with the fact that it's saying rare, because we use rare rules all the time. They're supposed to be rare, and we tend to use them often. So once this bill passes, we can use it as often as we want to. I myself can petition the AG on any piece of legislation that I feel that, you know, the DAs and other rural counties should be doing. I can go to the AG and tell the AG he needs to petition the courts about what rural district attorneys should be doing and how they should be legislating their own county. So I do think we want to be careful. We're not going to know how much it costs. And we are truly using big government and stepping on the toes of small governments for
Representative Lamar,
political
do you
issues.
have a question in there?
I made a closing statement to the questions I was asking him about how much it's going to cost and the duration of the
Thank you,
time
Representative
serving.
Lamar. Chairman Williams, you're recognized.
Thank you, Chair Lady. Representative Campbell, is there a portion of the current TCA or state law that this General Assembly or any previous General Assembly you think is unnecessary to prosecute?
Representative Campbell.
Thank you, Madam Chair. We would all have our differences of opinion. If I were a district attorney that is not a county official, you are a state official, my daily goal would be able to make sure that we carry out the laws of the state of Tennessee. And if that were not the case, I'd resign and find another job.
Chairman Williams.
Thank you, Representative Campbell. I think that's the very reason why you're carrying this bill. I want to thank the Speaker for that. I think what we have is a few cases across the state where attorneys general have decided that they didn't want to prosecute to the full extent of the law that the Tennessee General Assembly has set aside. And unfortunately, because they're unwilling to enforce the laws and prosecute people, we have to have a temporary situation like this where we have to have someone appointed. And so I think it's important for this body to understand that we are a state of laws, just like we are a nation of laws, and we pass laws because we expect to protect the citizens of the state. And I thank the Speaker for this bill. I thank you for sponsoring. I look forward to supporting it.
Representative Shaw.
Just one quick last question. Understand something, because I think I understand what's been said, but so I'm just going to use my county. If I thought a district attorney was not doing his or her job, who could I call? What process would I use to get a pro tem to get that job done? Because it may be the state district attorney may not know. What would I need to do to get that done? Just in plain English, yeah.
Representative Campbell.
Thank you, Madam Chair. Certainly not putting a process in code with this, obviously, in terms of what you would need to present to the Attorney General. But just as a potential example is if you had video footage from a Jackson TV station or radio station audio where the district attorney has appeared on camera and said, hey, I am not going to prosecute any instance of a specific criminal offense that's in Tennessee law, regardless of the facts and circumstances, and you provide that to the Attorney General, I would hope that they would then petition the court under this potential law here for a district attorney general pro tem to be appointed by the court. Thank you. Thank you, Madam Chair.
Representative Shaw.
So you are saying then I could go through that process. That's what I'm getting at. I could go to the state, if I had that information, I could go to the state's general attorney and say, this is what the guy said, and I need you to appoint a pro tem. That's what I'm asking to get clarity. Yeah.
Representative Campbell.
Representative, we're not creating the process by which we wouldn't be determining who can and cannot approach the Attorney General with all due respect. We would simply be allowing the Attorney General, upon their own decision, to petition the court. And the court would then decide whether or not to appoint a district attorney general on a pro tem basis in this very specific circumstance where the district attorney general has determined that they're refusing to prosecute all instances of a criminal offense of a law created by the General Assembly of our state of Tennessee. Thank you, Madam Chair.
Thank you. And I would just a question of my own, or perhaps more of a comment, but as I understand this bill, what we're attempting to ensure is that the laws that are passed by the General Assembly are enforced by the prosecutors that are hired for the state to do just that. So I think in a nutshell, that's what this bill allows us to do, to make sure if there is a rogue DA or someone who doesn't agree with something that the legislative body has passed. I don't agree with many things that we've passed up here, but they've still passed, and they are the law of the land, and I must abide by it. And we expect that our elected officials would uphold those laws. So I think this is just making sure that those laws that the body has passed are enforced. Are there any other questions of the sponsor? Representative Lowell.
Sponsor, would you consider the Attorney General a impartial official to appoint or to petition the court?
Representative Campbell.
I would say that I would trust, regardless of party affiliation, that the Attorney General has an oath and responsibility to the people of Tennessee. And I would hope that they would be borrowing from the judiciary, fair and impartial in their process. And keep in mind here, the next step on something like this would be the court. We're not asking the Attorney General to make the decision. We're not giving the Attorney General the authority to make the decision. All we're allowing, if we pass this, is to let the Attorney General petition the court for something that the court can legally do today. And it's creating an avenue by which we hope would see that state law gets enforced in all 95 counties. Thank you.
Representative Lowell.
And thank you. I think most people just wants to see the scales of justice to be balanced, and I think this bill does that. So thank you, and I'm glad to support it.
Thank you. Thank you, Madam Chair.
Thank you. Are there other questions?
Question on the bill.
Question has been called. Are there any objections to the calling of the question? Seeing none, we are now voting on House Bill HB 71. Going on to calendar and rules. All those in favor, please signify by saying aye. Aye. Any opposed? Let the record show the ayes have it. House Bill 71 moves on to calendar and rules. The next item on our agenda is number 4 on your calendar, House Bill 74 by Representative Garrett. Representative Garrett, your recognize you have a motion and a second. Please tell us what your bill does.
Thank you, Madam Chair, and I believe my bill has an amendment.
That bill is, that amendment is traveling with the bill, I'm
Okay,
told.
just wanna make sure. Thank you, Madam Chair. This legislation is one legislation that's filed by our Speaker Sexton, and I am carrying for him. It requires the Attorney General to seek an injunction of a member of a Board of Education to compel them to comply with an executive order issued during the state of emergency. If they do not, the fiscal impact of this bill is actually if a civil penalty is imposed on that on that board of Education member who refuses to comply with the executive order. So with that, Madam Chairman, I will be able to address any questions.
You've heard the
Or I renew my
explanation.
motion.
You've heard the explanation. Representative Miller, you're recognized.
Thank you, Madam Chair. For clarification, you mentioned, I'm reading a $10,000 for failure to enforce or execute emergency orders. For an example, you take your Board of Education, how many members are on there?
Ooh, that's a good question. I think 12, maybe 8. Can't remember. Several.
So does it mean every one of those individuals could be fined $10,000 plus $1,000 per day?
Representative Garrett.
It's up to 10,000 if they refuse to comply with an executive order during a state of emergency issued by our governor.
So
Representative Miller.
For an example, if your 12-member board decides to take a vote and a majority win that vote, but the remaining members who did not vote to execute the governor's orders, will they be fined?
My understanding is if the Board of Education and all members pass the legislation, they could be subject to this fine if they do not comply with the executive order.
Representative
Again,
Miller.
I'm not suggesting that all members will vote for, but let's say half of the members or minority of the members will not vote for to apply to the law. Will they be fined?
That would be up, this would be required to go for an injunction, and that could be up to the judge at that point on what the judge decides the civil penalty is under this legislation, but they can fine them up to $10,000. Whether they fine board members that vote against it or for it, that would be up to the judge.
Okay. Thank you. Thank you, Madam Chair.
Are there other questions? Leader Lamberth.
Move previous question.
Representative Shaw, you're recognized.
So we're going to cut the baby in two here on this one. In other words, you know that story about Solomon in the Bible. I don't, but we are going to cut the baby in two here, because what you're saying is that it doesn't matter what the school board decide to do about their local issues. You may have whatever going on. If the executive order says you don't have to get the vaccine, you don't have to wear the mask, anything, and half that school board, or say the majority of that school board, vote with that executive order, but those who do not vote with that executive order is actually going to be fined. Is that what I'm hearing?
Representative Garrett.
That'll be up to the judge at that point.
Representative Shaw.
I don't know if I understand that. If you pass in the legislation to say that's what it's going to be, then the judge got to follow the orders of the law, correct?
Representative Garrett.
Thank you, Madam Chair. What a writ of mandamus is it's an order that they're telling the board that they have to comply with this specific order. And the judge would prepare that if the judge decides that they're not complying with the order. So if they don't comply with the order, if they are asked to comply and they do not comply, then it's going to be up to the judge whether or not fines are warranted based upon that non-compliance of an executive order that's issued during a state of emergency. So it's very limited circumstances that this is going to apply.
Representative Shaw.
Well, I know I heard our governor say the other day that he certainly defy any executive orders from national level. I know he's given some on state level, but he basically said publicly he didn't want to deal with anything down from Washington. But I'm trying to figure out how we keep from cutting the baby half in two here, because it's kind of like here, we got an option to vote yes or no. And basically what I'm hearing, and maybe I'm wrong, maybe I'm interpreting this wrong, but I'm hearing you say whoever don't apply with that executive order based upon the judge's opinion and you passing it, putting it in the law, they are actually going to be fined, whether it's 2, 3, or whatever. That's my interpretation. So if I'm wrong, please help me. Thank you.
Representative Garrett.
I don't know whether, I can't say whether or not you're wrong on your own interpretation, but all I can tell you is that regardless how a vote may fall in a Board of Education meeting, that's going to be up to the judge on how that vote comes out if they all vote or half of them vote to not comply with the law. That's going to be up to the judge.
The question was called. Any objections to the calling of the question? Seeing none, we are voting on House Bill 74. All those in favor, please signify by saying aye. Aye. Any opposed? No. The ayes have it. House Bill 74 moves on to calendar and rules. Thank you.
Thank you, Madam Chair and Committee.
Representative Garrett. We are now back to item number 2 on our calendar. We're going to roll that 2 spaces. Oh. We are going to move House Bill 76 2 spaces. That brings us to item number 5, House Bill 29 by Chairman Moody. Chairman Moody, you're recognized.
Motion.
We have a motion and a second. Chairman Moody.
Thank you, Chair Lady. And members, I was notified a little while ago that the Senate did not pass this, so we'll take it off notice.
Thank you, Chairman Moody. That brings us to item number 6, House Bill 53 by Chairman Reagan. Chairman Reagan, you're recognized.
Thank you, Chairman and Committee. Appreciate the opportunity to speak. It is my intent to take this bill off notice, but before I do, I want to explain to the committee how it got here and why it went through the other committees. The big bill that was passed in the COVID committee to begin with actually contains elements of this bill. The Senate sponsor that I have with this bill decided that the Senate would not pursue it in lieu of letting it go through that. With that explanation, I would like to thank the committee for their consideration and request that this bill be taken off notice.
Thank you, Mr. Sponsor. The bill is taken off notice. That brings us back to House Bill 76. I think we need some more information from our fiscal review folks, so we're going to take a short recess. We will be back at 5 o'clock. Thank you. Members, for your information, House Bill 76, there is an amendment to the bill. It will be up on your dashboard in just a minute, so please, you'll have an opportunity to look over that during this recess. Thank you.
The original bill.
Finance, Ways, and Means is back in session, and we are now ready for the long-awaited, much-anticipated Chairman Vaughn. We have a motion and a second. Chairman Vaughn, if you would share with us what your bill does.
Bill, which rewrites the bill. The amendment is drafting code 010338, I believe, that y'all have been provided a copy of it. Today,
We are, just for the record, Chairman Vaughn, excuse me, we're on item 2, House Bill 76. We are now discussing amendment 01338. I'm sorry, 10338.
that is correct.
We have a motion and a second on the amendment. Chairman Vaughn, please proceed.
Thank you, Madam Chairman. I appreciate that. Just in the course of about 6 hours today, we have made government smaller because the original bill was 5 pages and the amendment's down to 3 now. So this bill, if you determine to move it on, addresses 3 separate areas. One is who gets to determine quarantine guidelines for an individual or a place of business. What this law proposes is that authority lies with our State Commissioner of Health. The second act, but let me say this though, but those procedures will come before the Government Operations Committee of this General Assembly to comply with the Uniform Administrative Procedures Act. So that is the first tenet of this amendment. The second tenet, which is important to me, is that in the section 4, or that's TCA section 682609, we deleted a section and added it this way. Let me see if I can give this for the committees, because these are sections of the code that frankly I am getting to be more familiar with, but only here in the short time. Okay, the county health officer is what this deals with. The county health officer is empowered to order, and it gives a number of things. And then section 4 says rules and regulations as are necessary or appropriate to protect the general health and safety of the county. We are removing that language and replacing it with the following. Except during a declared state of emergency for a COVID-19 pandemic, rules and regulations as are necessary or appropriate to protect the general health and safety of the county. So what we're doing here is, with that clause added into that front of that section, that brings the authority for handling COVID-19 related matters back under the state for all counties, not just the 89, but it also includes now the 6 counties that have independent health boards. So that's what we did there is in the absence of that, the state health department will, and the governor's administration will take care of that. Finally, in section 3, it amends section 682603. And to keep y'all from having to play Bible sword drill, I'll let you know what that one says. 686203, section A is amended by deleting subdivision 6. Right now, subdivision 6 says, if the commissioner, what this does is this establishes who appoints a county health director in a health department. And so it says the county health director shall be appointed by the commissioner of health or by the commissioner's designee. As we go down through the body of this, section 6 of that paragraph says, if the commissioner appoints a county health director pursuant to this subsection A, the appointment shall be made by the commissioner in concurrence with the county mayor of the county in which the appointment is made. What this new language that we're offering suggests is that when the commissioner appoints a county health director pursuant to subsection, The appointment shall be made in writing by the commissioner in concurrence with the county mayor of the county for which the appointment is made, but then we set apart and distinguish how that concurrence is obtained. The mayor shall submit a slate of not more than 3 nominees to the commissioner for consideration within 10 days of a request for nominees by the commissioner. The commissioner may appoint a health director from that list of nominees, or they may request additional nominees, or may appoint someone to the position that has not been nominated by the mayor. If the commissioner appoints someone who is not a nominee of the mayor, the commissioner must first consult with the mayor and provide written justification as to why one of the original nominees was not selected. That's the third item that we're doing with this amendment. And then finally, in section 4, we talk about the fact that except for the new quarantine guidelines, county health departments or board of healths in existence still remain in existence, and their regulations still remain in full force to the extent that they don't conflict with section 1. And so that is, then the last item says, except as provided in section 1 of this act, the quarantine of any place. There's some language that's changed out. Let's see, 682609. If you'd indulge me, Madam Chair, I'll read 682609, subsection 1 for us. The county health officer is empowered to order the quarantine of any place or person if the county health officer finds that quarantine is necessary to protect the public health from an epidemic. The new language that we would propose would read, the county health officer is empowered to order the quarantine of any place, or except as provided in section 1 of this act, the quarantine of any place or person if the county health officer finds. So in other words, it's the same language, but it does reference the fact that we've changed the guidelines for quarantine in section 1. And so that, Madam Chair, I'm sure that was crystal clear to all here. And so if you would indulge me, I'll renew my motion.
Thank you, Mr. Sponsor. And just in case that wasn't totally clear to everyone, we will entertain questions. And Representative Lowell, you're recognized.
Thank you, Madam Chairman. What's the length of the appointed positions as far as when somebody's appointed, how long will they serve?
Chairman Vaughn.
Allow me a moment, Madam Chair, to reflect on TCA Chapter 68, Section 2. It does not specify, Madam Chair, it does not specify a duration of the appointment. And that's existing code does not specify the duration of the appointment.
Thank you. And Representative Russell, I misspoke and called you by your first name earlier. I do apologize, but when you have 2 last names and it's late in the day, it's confusing. So I do apologize.
That's all right, Madam Chairman. I've been called worse.
But not today, I hope.
No, thank you. So just to be clear, the health director will be appointed by the Commissioner of Health at the will of the commissioner to last as long as the commissioner wants that health director appointed for.
That is correct.
Thank you.
Chairman Zachary.
Thank you, Madam Chair. Chairman Vaughn, thank you for bringing this bill. As a representative of Knox County, one of the greatest frustrations we've had during these last 19 months is the inconsistency. It's been a real frustration for the people of Knox County. I had a bill similar to this, and as I mentioned to you, I appreciate you running yours so I didn't have to run mine. But this is long overdue. It creates consistency in all 95 counties during a pandemic and will eliminate much frustration and, again, provide consistency and set expectations so people know exactly what we're doing from Memphis to Mountain City. So thank you for bringing the bill.
Thank you, sir. That was the intent of the bill, was to create that consistency and avoid confusion.
Other questions? Question has been called on the bill. Any objections to the calling of the question? I'm sorry, we're on the amendment. I tell you, it's late in the day. We are voting without objection on the amendment 10338. All in favor, please signify by saying aye.
Aye.
Any opposed? The amendment carries. Now the question has been called on the bill. Any objection to the calling of the question? Seeing none, we are voting on House Bill 76. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. House Bill 76 moves on to calendar and rules.
Thank you, Madam Chair, and let me say I do appreciate the patience of the Finance, Ways and Means Committee, so much so that I'm going to hush now and exit stage left.
We can't tell you how much we appreciate that. Thank you so much. That brings us back to item number 1 on the calendar. We will recess to the call of the chair. We'll take up item number 1 when we come back together again. So with that, we are recessed again to the call of the chair.